Welcome everybody to our ongoing series, Truth and Reconciliation, Calls to Action 57. My name is Ted Cadwallader. I'm a Director of Instruction at Nanaimo Ladysmith Public Schools. I want to start off just acknowledging this beautiful territory that I have the opportunity to live and work and play on. I'm currently sitting at Tz'menis First Nation traditional territory. Our school district spans Natnawas, Snuneymuxw, and Tz'menis First Nations territory here on the beautiful southwest coast of what's now Canada. I'm joined with my amazing colleague, Stephanie Johnson, who we work together in Nanaimo Ladysmith Public Schools, and our efforts to try to learn as an organization on how to walk differently through the guidance of our knowledge keepers. I would usually be joined this morning also with our great friend, Tzonkwat and Lawrence Mitchell, who starts off our meetings asking our ancestors, our non-human relatives, and our grandchildren yet to be born to join us in this sacred space. And we're hoping that he can join us when he has time this morning. I also want to raise my hands to our colleagues at UBC Press, Carrie Kilmartin, for setting us up and introducing us to this incredible authors that have been able to join us over this series. They bring an amazing background of knowledge in so many different sectors beyond education, history, and in this case, law, with Jim Reynolds joining us today, but also great cultural knowledge and teachings, learnings that they've shared along the way. And so it's my great pleasure to introduce you to Jim Reynolds, who joins us today. When I was looking at your background, Jim, it started off with you at the London School of Economics, and there's only one other person that I know that's graduated from there. So now I have you and Mick Jagger on my list of graduates from the London School of Economics. Jim came to from the UK after an extensive law practice and teaching there. Came to BC in the 1980s, and I recall the 1980s. It was a disruptive time as Indigenous people were reasserting their inherent rights and title to the land and territories in what's now BC. And so you came at an auspicious time of great learning. And Jim's going to join us today to share his learnings of that time and how we got to where we are today with respect to his book, Aboriginal Peoples and the Law. So welcome, Jim.
Thank you very much, Ted. And thank you very much for giving me the opportunity to be with you today, even if it's electronically. I'm actually in Vancouver, so I'm in the traditional territory of the Musqueam, and I've had the great honor to work with the Musqueam for over 40 years now. And of course, that does go back to the early 80s and really the development of modern Aboriginal law. And I've been very fortunate to have been involved in some of the aspects of the development of the law. And I've tried to record that in my book. Now, I'm not quite sure how the PowerPoint should work.
I got it for you, Jim.
Great,
whenever you're ready.
So maybe if we could go to the next slide. The first slide is the title slide, the one following that, please.
Yeah, hold on. I'm just going to pull it up here.
I've got it sitting on mine too, Jim. That's why you saw the
glitch happening there. So, thank you.
Yeah, we're well set up.
Great. So I also have that on my screen. I'll work through the slides. I'd like to keep pretty much to the slide presentation. And then Stephanie, if you could move on at the end of the particular slide. So the book, as Ted mentioned, is Aboriginal Peoples and the Law. So thank you very much for the plug. I'm sure UBC Press will appreciate that. It's intended as an introduction. There are several fairly advanced texts, if you like, on Aboriginal law. This is intended more as an introduction. And I should stress that I'm dealing with Aboriginal law, not Indigenous law. And it's important to understand the difference. The term Indigenous law is now used as a term of art to refer to those laws which are specific to a particular Indigenous group. So you have Musqueam law, Cowichan law, and so on through the different Indigenous groups. They've all developed their own law, and obviously it's gone back thousands of years in many cases. So I'm not dealing with that. I certainly can't pretend to be an expert on Indigenous law, although again, through the Musqueam in particular, I've had the advantage of learning something about Indigenous legal systems. What my book does is to trace developments in the Canadian legal system, and that's what I mean by Aboriginal law, the law of the Canadian legal system, dealing with First Nations and other Indigenous people. I've called it as the subheading a critical introduction. Most of it, I could say, is descriptive. It tells you what the law is. But I've also, of course, taken the chance to give my own views on the law. And in particular, in the final chapter, I give my thoughts on the legal developments over the last 40 years or so, including looking at what I think would be the major questions for the future and some evaluation of the existing law. And in that final chapter, I've also talked a bit about what I see as the benefits and the limits of the law. And I think that's an important topic that I would like to cover today, because I think perhaps if you read the newspapers, listen to the radio, the television, you may think that the law is different from what it really is. There's a sense, I think, that somehow the lawyers and the courts are solving the problems which will enable the politicians and the public to kind of step back and let the lawyers and the judges get on with it. It's not that simple. And that's really what I would like to talk about today. So moving on to the next slide, I think there's no question that there have been some very significant benefits to what's happened in the last 40 odd years. But at the same time, I think there are some significant limitations. And I'd like to start with a quotation from a law professor, Patrick McHugh, one of the leading authorities on Aboriginal law. And he wrote, "The provision of legal rights has not made tribes worse off, but equally it is less clear whether it has significantly or even marginally improved their general lot." And I think that's a quote that's worth considering, because some Indigenous groups, without question, have reaped the benefits of the developments in the law. And I've had, as I mentioned, the advantage of working with the Musqueam and to some extent with the Squamish and Tsleil-Waututh, who are neighboring Salish tribes, Salish groups, on various joint developments. And over the last 10, 20, 30 years, Musqueam has had land returned to it. And that's very significant. The history of Indigenous people, of course, is by and large their dispossession. It's only really been in the last 30 years or so that there's been return of some of that land. And in the case of the Musqueam, they've reacquired, if you want to use that term, or had returned to them, land that's valued at market value of over $1 billion. And that's, if someone had said 40 years ago to me when I was starting off in Canada in Aboriginal law that this would happen, I could never have believed it. And I don't think anyone else involved, the relatively few of us who were acting for First Nations back then, would have believed that we would have got the kind of successes that Aboriginal groups have had in recent years. In noting the return of the land, most of which, or a significant part of which, certainly in Vancouver, will be used for land development to generate income for the First Nations, improve the living standards of the community members. But in noting that, and those benefits are likely to come more, will come in the future rather than now, I think it is important to recognize that there's still significant socioeconomic challenges. It's not as if they've suddenly had a great amount of wealth fall upon them. It's going to take years for the land to be developed. And there's always a risk involved in land development, as we've seen in recent years. But no question, some First Nations, such as Musqueam, Squamish, Tsleil-Waututh, have been beneficiaries. Another BC First Nation that's really benefited will be the Chilcotin, who have now had Aboriginal title recognized in their traditional territory. And I'd like to mention that briefly later. So if we can move on to the next slide, please, Stephanie. So if you look at some of the factors that have been responsible for the success, without question, it's been the strength of claim to land and resources. And there's really no doubt in law that the Musqueam, Squamish, Tsleil-Waututh do have Aboriginal title. So they have a very strong claim, legal claim. Another great benefit that they have is that they're in the commercial mainstream, to use an expression from some of the court cases, meaning that they are in the Vancouver, the Lower Mainland area, so they have access to resources, to lawyers, to various experts, historians, anthropologists, so on, that can help them bring the cases. They also have access to financing. If they're successful in their court cases and they get land returned to them, then they have access to financing to do the development. So relatively speaking, they're well positioned geographically and otherwise to take advantage. And I think if you look at Indigenous groups across the country, they're kind of on a continuum. You have at one end Musqueam and Squamish, who are relatively well off. And I want to stress that that has to be seen in context, relatively, compared with non-Indigenous people. As I know from working with the Musqueam for the last 40 odd years, there are some real issues and real challenges within that community because of lack of wealth, which of course results from colonialization. But if you compare Musqueam with many other First Nations, you could see that they're relatively well off. And in particular, if you look at First Nations that have signed historical treaties, they're kind of at the other end of the scale. They had treaties signed, say in the 19th century, the numbered treaties across the prairies, which essentially in law means that they can't assert Aboriginal title and Aboriginal rights. Their rights are now contained within the treaties, and those treaties conferred very limited benefit. So when you read of cases like Chilcotin, you should please bear in mind that there may be relatively few First Nations across the country, let alone other Indigenous groups, Métis, for example, which are in as favorable legal position. Most BC First Nations, as I'm sure you're aware, are not subject to treaty. Vancouver Island, of course, is an exception in that there are 14 so-called Douglas treaties dating from the 1850s. Again, those treaties conferred limited benefit, basically one-time financial payments. And in return for that, those nations gave up, surrendered under the wording of the treaty, all their property in their traditional territories, or at least the territories as set out in the treaties, with what was said to be the limited exceptions for their village sites and their enclosed fields. And they also they reserved the right to hunt and fish outside of occupied areas. So if the land had been settled, then they don't have that right. Looking at First Nations, if you like, at the other extreme to Musqueam, we could take a case, a Supreme Court of Canada decision, 2006, the God's Lake decision, which involved a small remote Manitoba community, which had signed one of these historical treaties. I think it's treaty number 6. And in that decision, Justice Binney, one of the Supreme Court judges, pointed out that the God's Lake Reserve had very few economic opportunities. There were fewer than 1,300 people, but they accounted for 10% of the TB cases in Manitoba. Just go on to the next slide, Stephanie. Only 10% of their homes had basic sewer systems, so 90% did not have even basic sewer systems. And Justice Binney said they had inadequate resources to achieve any kind of financial independence in a market economy. They had no access to the commercial mainstream. I think they're about 1,000 kilometers north of Winnipeg. And he said they have no realistic prospects of ever obtaining access to the commercial mainstream. And you have to kind of step back and say, well, how will developments over the last 30, 40 years in Aboriginal law really assist these communities? They sign treaty, so it's going to be very difficult for them to show any Aboriginal title, Aboriginal rights. They basically surrendered those in return for the treaties. Those treaties gave outdated benefits. Essentially, what those treaties were intended to do was to convert hunting-gatherer people, the Indigenous groups that had traditionally hunted on the prairies in that case, convert them into farmers. So the treaties gave them access to agricultural implements, grain, horses, that kind of thing, plus a payment of about $5 a year to each of the members, and I think $15 a year, and a suit of clothing to the chiefs and the headmen. But those were the benefits, pretty meager at the time, and certainly overtaken by events. And the Supreme Court of Canada has noted in several cases that the treaties were likely to have been little understood by the Aboriginal groups. They were written, number one, and Aboriginal people by and large were not able to read English at that time. They weren't translated except by government agents into the Indigenous language. And above all, the Indigenous groups really had no choice. The settlers were going to come, like it or not, whether treaties were signed or not. So the groups involved just had to take what they were offered. It was very one-sided. And the Supreme Court of Canada has to some extent recognized all those concerns, but having expressed the concerns, they've upheld the treaties in any event. So moving on, if we could. The next slide I've called the vagaries of litigation. And I think it's important to note that some Indigenous groups will be unsuccessful in the litigation for reasons that have nothing to do with the merits of their case. The cost of litigation, for example, runs into tens of millions of dollars for major cases. The delays involved in litigation taking years, even decades. And the fact that litigation is a winner and loser proposition. We talk about the forensic lottery. In most cases, there's going to be a clear winner and a clear loser. So sometimes the Indigenous groups win, and if you like, the Crown is, the government is the loser. Sometimes it's the other way. So it's a win or lose situation. And sometimes other Indigenous groups are affected by the litigation. And I made a reference there to the Cowichan litigation you may have heard of, essentially Cowichan tribes asserting a claim to land in Richmond, Aboriginal title claim. Richmond, of course, is within the traditional territory of the Musqueam, as well as of other groups. So whoever wins in the Cowichan litigation, one or more other Indigenous groups is going to feel that their rights have not been recognized. And of course, one of the issues about Aboriginal title, Aboriginal rights in BC is the extent of overlapping claims. And as I mentioned, litigation is sometimes referred to as a lottery, and it really is a matter of luck. Sometimes what evidence has been preserved, especially when you look at these cases going back decades and indeed centuries, what evidence has been preserved and how, what witnesses are still available, what elders are still available, able to give evidence of the oral history, what documents may have been recorded. And I made a reference there to one Vancouver Island First Nation that has been very successful in its fishing rights litigation, the Ahousaht Nuchalnuth tribe. And in fact, there was a decision last week in the BC Court of Appeal confirming their Aboriginal right to fish. And they benefited from their foresight in taking an English sailor captive in about 1800, I think it's John Jewett. And he wrote an account of his time as a captive of the Ahousaht, including an account of their fishing. And that turned out to be critical, whatever it was, almost 200 years later, in their being able to successfully prove that they had a right to fish. One thing that I should mention is the human cost of litigation. Litigation, as some of you may know if you've had the misfortune perhaps of being involved, can be almost traumatic, very stressful, goes on for a long time. The consequences could be significant. Having to give evidence can be very difficult. It's difficult to see elders being cross-examined, difficult to see very fundamental beliefs being challenged, difficult to be in a confrontational situation with the Crown, but also, as I mentioned, perhaps with other Indigenous people. And of course, litigation, especially major litigation, can divert you from other activities which may in fact be more beneficial, such as political action. Litigation is also somewhat passive on the part of the clients. Obviously, lawyers have to act in accordance with instructions, what the clients tell them to do, but litigation has a life of its own. And once it starts, it's really leaving it to the lawyers to see it through to the end. And again, I don't want to downplay the role that Indigenous witnesses play, that's critical, but the question of strategy in litigation really does come down to what the lawyers recommend as being the best strategy to achieve result. One other aspect of litigation is its adversarial nature rather than inquisitorial. And that's common to what's called the common law system, and the system of law that we have in Canada, outside of Quebec anyway, which derives from the English legal system. Basically, litigation is a contest between two parties, a bit like a soccer match. So the role of the judge is to be the umpire, the ref between two competing parties. So it's up to the parties involved to bring forward the evidence. And they have to obviously do what they can to prove their case, but they're not obligated to bring forward all relevant facts. It's not like a kind of scientific inquiry to find out what's relevant, look at all relevant issues and come up with a decision that's in the best interests of the public. It's pretty much you win, you lose kind of situation. Stephanie, on the next slide, I mentioned that litigation can often have a mixed result. And this is especially the case, it seems, in Aboriginal law cases. If you look at some of the leading cases, it seems that the Supreme Court of Canada always wants to take away to some extent what it's given with the other hand. It advances for First Nations. The court seems to want to balance with some benefit to the government at the same time. And looking at a couple of the leading cases, Sparrow, which was a decision involving the Musqueam, which gave a recognized constitutional protection for the Aboriginal right to fish. Section 35 of the Constitution, as you probably know, recognizes and affirms existing Aboriginal and treaty rights. And Sparrow was the first case where the court applied that. But the court also went on to say that the government retained the right to infringe Aboriginal rights. The government has the ability to infringe Aboriginal rights if they can, quote, justify those rights, which essentially comes down to, under the current law, the court saying it's in the public interest that the government infringe, limit the Aboriginal right. They impose restrictions, for example, on the right to fish. And another leading case, Chilcotin, was a decision about 5 years ago, a major decision, which for the first time recognized on the ground, as it were, that Aboriginal title exists. And the Chilcotin, their Aboriginal title was recognized. But in the course of that decision, the Supreme Court of Canada extended this ability to infringe from the federal government, which Sparrow in other cases had recognized indeed did have the right to infringe. But in that case in Chilcotin, the Supreme Court extended that ability to fringe to all the provincial governments, which was a bit surprising to say the least, since under the Constitution, Aboriginal rights are basically a federal, not a provincial matter. Anyway, if a First Nation does want to go to court, then it has to comply with all the technical rules of procedure and evidence, although there is some relaxation. Again, to quote Justice Binney, Aboriginal and treaty rights, like much else in the courts, is often won or lost in the trenches of mundane procedure. And one thing that's worth special note, limitation defenses. Those are the defenses which basically say you have to bring a court case within a certain period, often 2 years, sometimes 6 years. It's quite technical and varies. But if you don't bring your action within that time period, then you're statute barred. You can't bring the action thereafter. And that's likely to become increasingly a problem for Indigenous groups. When the modern law of Aboriginal rights was being developed in the 80s, in the 90s, courts were somewhat lenient, saying this is a new area of the law. People didn't know that they had the right to sue. Now courts are saying, well, this is now a fairly well-established area. There's greater access to lawyers who should know when you have a legal right. So basically, courts are now being more difficult in saying, bring your court case within the right period. If you sleep on your rights, then you're going to be out of time and you won't be able to pursue the claim in court. Moving, if we could, to the next slide. Negotiations. The Supreme Court of Canada has repeatedly urged negotiations and, in a sense, discouraged litigation. And one way it's done that is to develop a major development in the law since about 2005, the Hyder decision in the Supreme Court of Canada, where the court said that even before an Indigenous group can prove its right, whether it's a treaty right or Aboriginal right, if the government is proposing to do something that could potentially infringe an asserted right, so asserted rather than proven right, then the government still had to consult. And that is an area that's kind of dominated in recent years. So the court has done that really to encourage negotiation rather than litigation. And the court also said in the Chilcotin case that there's a legal duty on the government to negotiate in good faith. But it's important to note that negotiation and litigation are not in watertight boxes. They're components of a successful strategy. In my experience, governments will only negotiate seriously if they're under pressure, and litigation or the threat of litigation is usually the only leverage, certainly the best leverage that Indigenous groups have to bring the government to the table to get them to negotiate. It's not like a dispute with the supplier. If you're not happy with the price that you're offered by supplier A, then you can go to supplier B or C and hopefully negotiate a better deal. That's not the case with the government. The government really has little incentive to negotiate. It's not usually in their best interest to do that. And that's why litigation is so important, to concentrate their attention, hit them over the head with a threat to get them to the negotiating table. If we move on to the next slide, if we could, thanks, Stephanie. Litigation is usually the BATNA, the best alternative to negotiated agreement for Indigenous groups. Again, they have very limited alternatives to litigation if they can't reach a negotiated agreement. However, I think if you step back, negotiations really to be successful require much more equality in bargaining power than you'll find between governments. And by the way, when I say governments, I mean non-Indigenous governments. Obviously, Indigenous groups have their own government, but there's not much equality of bargaining power between Canada or BC and a group, even like the Cowichan, who I believe have about 5,000 members, and I believe they're the largest BC First Nation. So many First Nations in BC have 300, 400, 500 members. So they're at a clear disadvantage in trying to negotiate with the government, which has really awesome power. And a study was carried out by Professor Ankatara back in 2013. He wrote a book, Negotiating the Deal, and he looked at treaty negotiations across Canada. And his conclusion was that to be successful, Indigenous groups should only negotiate those issues which the government wants to negotiate. They should avoid confrontation, and they should attempt to persuade the government to do the deal. So it's pretty one-sided negotiations, and that probably explains why now, I think almost 25 years after the BC treaty process started, we only have a handful of treaties negotiated under the BC process. And if you look at treaties across the country and other agreements negotiated across the country, they're relatively few given the large number of claims. It's going to be decades before all the BC groups that are in the treaty process have any prospect of concluding a treaty. And now looking, if I could, at the limitations for both litigation and negotiation, it's important to note that it's really on a case-by-case basis, particular groups that are bringing the litigation, engaging in the negotiation, and the outcome is normally limited to those parties. Yes, cases like Sparrow, Chilcotin do establish important legal principles, but the governments are in no hurry to apply those principles to other groups. They're usually quite reluctant to do so, and the fact that one group has been successful in negotiations doesn't mean to say the government will extend the benefit of the outcome of those negotiations to other groups. It loves to come up with lists of Indigenous groups that are permitted to negotiate, and the vast majority of the government simply won't deal with them. And stepping back from litigation negotiation, I have to say that I had problems with really the whole approach to dealing with the claims of Indigenous groups and basing the outcome on a kind of private property approach, a kind of liberal approach to resolving issues, individualism, defending property rights. That's really applied to this area, in my view, wrongly. The groups that have been successful are those who are able to show that they have these rights rather than on what their needs are. And I think it's unfair to distribute benefits primarily to groups which are fortunate enough to still enjoy Aboriginal rights and title, or have been able to negotiate modern treaty rights. And if we look again at First Nations like the God's Lake First Nation in Manitoba and many other isolated remote communities, look at those with historical treaties, there have been various studies carried out which show that those groups are falling further and further behind other groups that have been successful either in litigation or in concluding modern treaties. And that will, of course, continue into the future because those groups are bound by the historical treaties and the limited benefits under those treaties. Groups, like most of those in BC that don't have historical treaties to kind of tie them down, are in a much better position. And over time, that will get reflected in community well-being, things like employment and health statistics and so on. Moving on, if we could, Stephanie. Looking at some of the distinctions, if you like, between law and politics, political measures can bring much more general benefit than litigation or negotiation. The courts simply don't have the resources that governments have. Courts don't have funds that they can make available to resolve issues. Courts don't have the ability to pass legislation. Again, courts basically decide as between two parties which one will be successful, which one won't be. And if we're to close the very significant socio-economic gap between Indigenous and non-Indigenous people, we need to make the kind of fundamental changes that were recommended back in 1996 by the Royal Commission on Aboriginal Peoples. And that was by far the best study that's ever been done in Canada, probably in North America, looking at issues affecting Indigenous people. 4,000 pages, took 5 years, made over 400 recommendations, fundamental recommendations, which would have fundamentally changed the relationship between Indigenous and non-Indigenous people. And they came up with a specific 20-year plan. Bear in mind that their report was over 20 years ago now, to close the gap. And perhaps if that report had been listened to, if the gap would have been very significantly closed, and the issues that continue to plague Indigenous groups would have been largely resolved. Only time could have told that. But in fact, of course, the government has just ignored that, ignored the report, ignored the recommendations. I guess from the government's point of view, the report served its purpose. It was set up after the ochre crisis to try and bring about peace and prevent another ochre. And I suppose the commission did that. So the government, having achieved its purpose, probably saw no reason to do anything. The next slide, I've headed Judges and Politics, because I don't want to suggest that judges do not make political decisions. Of course they do. Judges used to pretend, and some still pretend, that all they do is apply the law. But of course they make the law in very significant ways, and especially in the case of Aboriginal law, which is by and large the result of developments by the Supreme Court of Canada. And they make law in things like this test of justification, the ability of non-Indigenous governments to limit Indigenous, Aboriginal and treaty rights. Judges are making decisions on what's in the public interest. And surely that can only be a political decision. We hear a lot about reconciliation, and the legal definition of reconciliation is to balance constitutionally protected Aboriginal rights with the interests of all Canadians. So when the Supreme Court of Canada talks about reconciliation, at least how they're referring to that these days, they're talking about balancing Aboriginal rights. And again, should bear in mind that these are constitutionally protected rights with the interests of all Canadians. And that's been said to be the fundamental objective of modern Aboriginal law. And here we're talking about minority rights. Indigenous people make up about 5% of the population. And we're talking about limiting those rights in the interests of the majority. Usually when we think about constitutional rights, or often when we think about constitutional rights, we're thinking about the rights of minority groups and how the Constitution protects those rights. And that's true of Aboriginal and treaty rights, so far as Section 35 of the Constitution is concerned, which recognizes and affirms those rights. But the Supreme Court of Canada has given a basis to the government to limit those rights. And if we could go on to the next slide, that's, as Justice McLaughlin said in one of the cases, that's ultimately more of a political decision than a legal decision. And it's not democratic. Judges are neither elected nor are they representative. And in fairness to the judges, I should say this wasn't really something they asked for. When the Constitution was amended 1982 to recognize Aboriginal and treaty rights, that's all that the politicians did. Existing Aboriginal and treaty rights are hereby recognized and affirmed. And that's such a vague statement that it's taken 30 or 40 years of litigation to try and give some kind of substance to that. It's important to note that there's a lack of meaningful Indigenous participation in the judicial lawmaking. When Supreme Court of Judges are appointed, there's really no meaningful hearing. In Canada, often there is no hearing, and it's really not a searching inquiry that you find, for example, with the US Supreme Court. And there are no Indigenous judges on the Supreme Court of Canada, despite recommendations going back decades. In fact, there are no judges from minority groups on the Supreme Court, all 9 justices. None of the 9 justices come from a minority background. And that's also true, by and large, for other courts in Canada. Very inadequate representation. And I'm talking statistically, again, Indigenous people make up 5% of the population. They certainly don't make up 5% of judges. And litigation really isn't designed to result in good policy. Again, litigation is to decide between 2 adversarial parties. It's really you win, you lose, rather than how should we make law that conforms to good policy. What the judges deal with is basically what the parties and interveners, these are third parties allowed to intervene, to get involved, to assist the court. The judges are limited to what they choose to put before the court, rather than a searching inquiry to make sure that all relevant considerations are brought forward. There are strict limits on oral and written argument. You may think, listening to me, that an hour is a very long time, but really to make your arguments before the Supreme Court of Canada on a major legal issue, and they only deal with important points of law, to be limited as lawyers are to 1 hour of oral argument is often simply inadequate. The main weight that's given now is to the written argument rather than the oral argument, but that's limited to 40 pages for the parties, and that has to contain a lot of mandatory required material. So believe me, when you're trying to get what are often very complex points across, being limited to maybe 20 pages are meaningful, maybe 25, depending on the case, it really is a challenge. And litigation, the process is that, of course, you have the hearing, then the judges reserve, they take about 6 months, the Supreme Court of Canada, to come down with the decision. And once the decision is announced, that's it. It's not announced in draft form. There's no opportunity for the parties or for the public or experts in the area to clarify, to make comments. It's just announced and the law is made, and we have to live with it. And often that means that there's further cases required to clarify what the court was saying. And in conclusion, if we could thanks, Stephanie. It's clear that there have been major developments in the last 40 years or so in Aboriginal law. I think it's also clear that they've been very important developments. Probably they've been the most significant developments in what really has happened, what real changes have been made, as opposed to, and I don't want to downplay the Royal Commission in '96, it certainly wasn't the fault of the commissioners, but that really didn't bring about any changes. The TRC report, time will tell whether those recommendations are implemented. I think relatively few have. There have been major announcements by the Trudeau government, which 3 or 4 years later have really resulted in nothing. Litigation, on the other hand, hasn't resulted in improved conditions for some Indigenous groups. But as I've said, other groups have not benefited, and it's perhaps unlikely that they will benefit. I think the real solution to what are essentially political issues have to come primarily from the political, not the legal arena. You can't leave it to the lawyers, to the judges. And yet that's really what politicians have to some extent been allowed to do. The relationship between Indigenous, non-Indigenous people has become a judicial matter. It's become a legal matter rather than what it should be, a political matter, a social matter, an economic matter. You can't just leave it to the judges. And although, as I've noted, there have been improvements for specific Indigenous groups, I don't think the approach has generally worked in terms of improving the situation, the challenges faced by Indigenous groups. And I referred to a 2015 study carried out by the Department of Aboriginal Affairs, and that compared living and income standards between First Nations and non-Indigenous people between 1981 and 2011, so what, that 30-year period. And it showed that there was no reduction in the gap in incomes and living standards between First Nations and non-Indigenous people. So that's really the formative period for modern Aboriginal law from 1980, say, and of course it's continued up to this year. And certainly over those 30 years, that socio-economic gap has not narrowed, it's remained So the law has not worked to limit that gap. So thank you very much. If we have time, I'm more than happy to answer questions.
It's great, Jim. Thank you for that that history over the last little while. Somewhat bleak, but we always operate on hope as well, and sometimes that leads us to understand this a little bit better, right? That maybe the litigation is not the tool that's going to get us closer to building a country where Indigenous peoples, First Nations peoples take that priority place. A couple of questions here. One early from Carrie. You had mentioned the return of land specifically to Musqueam, and her question was does that land return include control of water and mineral rights?
Yes, basically the way it's worked is that Musqueam and other groups have acquired what's called fee simple titles. So that's the same title that you have off reserve. The average homeowner will have fee simple title. So yes, to the extent that gold could be discovered or water, access to water on, say, the Jericho lands, that's a 90-acre site, Musqueam and Squamish Tsleil-Waututh have had returned to them in recent years. Whatever the resources are on those lands, they acquire as owner. And I guess I should make a distinction now between rights as owner and rights as a government. They are like any other fee simple owner in being subject to municipal regulation, provincial regulation. So, you know, if gold is discovered or whatever, yes, they have rights to those resources, but they're still governed by provincial municipal law.
Okay. Thank you. Yeah, give with one hand, sometimes it lives on the other
and
side.
Maybe I could make a general comment, which I don't think I've made, which is the law has recognized property rights, some property rights of Indigenous people. The law has not recognized to any extent governmental rights. Sovereignty is simply not recognized by the Canadian legal system. The Supreme Court of Canada has really avoided the issue, and where it's dealt with the issue, it has not upheld sovereignty claims.
Okay. Thank you for that. Yeah. This one from Shannon, she said she thought she'd read recently that courts also recognize that Indigenous groups should not be required to produce documentation of historical rights, as agreements were traditionally and culturally verbal agreements, and that in a recent ruling, courts are turning to governments and their legal representatives to prove or provide documentation that the historical rights or claims didn't exist. Is that out there?
I haven't heard of that development, and I would love to have seen it. I think what may be referred to is that the Supreme Court of Canada did say in the Dalgamuk decision that oral evidence, that's 1996, evidence of traditional practices, oral rather than written evidence, should be treated with the same respect as written evidence, because of course Indigenous groups often will not have any written evidence put forward. Sometimes, as with the Ahousaht, you may have a captive in that case, or the Chilcotin were fortunate to have a Jesuit priest write about their territory, but most Indigenous groups will have to rely upon oral history. And the court did say that that should be put on the same level. But having said that, the court later went on to limit the reliance on oral evidence. So, as I think I mentioned, there have been some changes made to make it a bit easier for Indigenous groups to bring litigation, but those changes have really not come very far.
Okay, Jim, I want to raise my hands and thanks for you joining us today. It is the way that your presentation today touched on points that Sakesh Henderson brought to us around his experience of developing the United Nations Declaration, and the way that Lindsay Burrows talked about the reclamation of language and judicial law based on Indigenous law, and bringing that to the forefront and how it was tied to language. This has been a great addition to that overall picture of Indigenous peoples and the reclamation of land and laws and language all being a complete piece. We're trying to do our place here in Nanaimo Ladysmith Public Schools, and I thank you for adding to that today. So,
Well, thank you very much for giving me the opportunity, Haska.
no,
Okay, bye everyone.